So in this second part of the recording, we're considering prescriptive jurisdiction, a state's power to enact rules of conduct. So let's consider first the idea of jurisdiction based on links. These are the obvious categories, especially territorial and nationality jurisdiction. So it's uncontroversial that a state should have authority to regulate events occurring on its territory. So this would typically be objective territorial jurisdiction. Where events occur on your territory, you can exercise jurisdiction over them. Subjective territorial jurisdiction is where you assert jurisdiction over conduct that is begun on your territory, but where its effects are felt in a different objective territorial state. So a trans-border crime may have more than one state of territorial jurisdiction. So smuggling offences, or the classic example of a murder committed by one person standing on one side of a border against a victim on the other, would be states involving multiple territorial jurisdictions. We move now to categories of extraterritorial jurisdiction, when states assert jurisdiction over events occurring outside their territory. The classic one being active nationality, so governing the criminal conduct of your citizens abroad by your own law, and then enforcing it when they return. But some states will also claim jurisdiction over crimes done to or offence against their nationals, and that is passive nationality jurisdiction. A ship or aircraft, when in international airspace or on the high seas, will be subject to the exclusive criminal jurisdiction of its state of registration, also called flag state jurisdiction. So events occurring on board that craft are regulated by the criminal law of that flag state alone. Protective jurisdiction is jurisdiction states assert in respect of their essential interests over events occurring abroad. The classic example being conspiracy abroad to smuggle drugs into a territory. The effects doctrine is an economic principle of jurisdiction, so this concerns acts abroad that aim to influence markets or the economy of a state, so typically antitrust or competition law issues. It might be thought of as also being very similar to objective territorial jurisdiction. And also states retain criminal jurisdiction over their armed forces serving abroad. So there'll be simultaneous criminal jurisdiction between the sending state of nationality and also the territorial state where they are present. Okay, so let's turn now to quasi-universal jurisdiction or treaty-based jurisdiction before in our third and final recording considering universal jurisdiction and enforcement jurisdiction. So the best summary of this concept is found in the Vaughan Low essay in your set text, and the general pattern of these treaties is that each state party agrees to criminalise conduct specified in the treaty and to assert jurisdiction over those defined crimes when committed on its territory or on one of its ships or by one of its nationals. Now, the second part of the principle is that states must also assert jurisdiction over those crimes if they are committed by a person found within its territory whom the state does not extradite to another state party having jurisdiction over the crime. In that way, a kind of treaty-based universal jurisdiction is established between the parties. So the idea here is it would ordinarily be another state who is a party to the treaty system that has jurisdiction based on territoriality or nationality. But if you do not send them to such a state for prosecution, you must enact a law enabling you to do it yourself, which is effectively a type of delegated jurisdiction. And the examples we discuss in class are the Convention Against Torture and the Suppression of Unlawful Acts Against the Safety of Maritime Navigation Convention. So that concludes the second of these two presentations, and the next one will consider universal jurisdiction and enforcement jurisdiction.